So, and that the placement you have, in order to, another part of it is you have to do a placement with a, so basically you have to do something regarding the custody, care, or placement of the child. And so it could be, so in a child support case, I just did a whole bunch of research on this. So in a child support case, somebody might be coming in on a 4D child support case. And on a pure child support case, the question is, under DC law, can you get to custody? In New Mexico, you have to. I mean, under statute, they will roll a custody, opportunity for custody into that same proceeding. But some other states don't. So whether or not child support can be, a pure child support case can be a forum for SIJ will depend on whether there's a way for the court to reach, at least to validate or to reach by consent or something, some kind of a placement or custody, even if they're not changing custody. But you have to open up the custody case to do it, and sometimes you might need to bring a custody case and then consolidate the actions. You have to figure out how to do that. So you have to. So the findings, the three findings, are that there was abuse, abandonment, or neglect by one parent, as I said, decided based on DC law on facts wherever they occurred. You have to show that reunification with the child is not viable with the parent who perpetrated the abuse, abandonment, or neglect. Now, reunification here, we're not. It does the training materials that came out on DHS made it clear. You don't have to have termination of parental rights. Okay, so it is not termination. It's nowhere near that. And so the way we kind of, the judges I train with talk about this is if you've issued a final order of custody, you've had a contested custody case or even a consent custody case before you. You've finished the custody case. You've made findings of abuse or abandonment, neglect as part of the custody case. In order to change that custody order, what has to happen in DC? How do you change the custody if you want to change something in a custody order after it's been issued? Modification. So, because you have to have a substantial change in circumstances or modification standard, at the moment that you're ruling, you can say, in order for this to change, there has to be a substantial change. I am setting it up this way. I don't believe that at this point in time, in this circumstances, that there's a viability that there's going to be reunification. He's been abusive. I'm putting this placement together so that the kid can be protected. That's it. You're not expected to be Houdini and decide what's going to happen 10 years from now if the child's 8. Okay? So that you can make that reunification isn't viable at this point in time based on what's before you in a case. And if your orders are final and your statute would require a substantial change in circumstances to change it, that's enough to make that finding at that point. They're not expecting you to predict what's going to happen in 10 years. And it's okay. So what would happen is, just so you know, the way SIJ is set up, if between the time of filing and adjudication, and there's some delay in these SIJ cases too, the child reunifies with the parents that you adjudicated that they couldn't reunify with, they lose access to SIJ. So there's a mechanism under immigration law to deal with that reunification issue. And then finally, you have to show that it's not in their best interest to return to their home country. And some of that is going to be a comparison. That's where the gang violence and some of those things can come in. But honestly, if you're deciding a placement, some of this can be just there's no viable placement. If you look at all the family members, and if your facts are that dad was abusive, dad was living in the home of grandma in Guatemala, the abuse occurred in grandma's home. There isn't anybody but grandma and dad in Guatemala. Mom's here, or aunt is here, and mom is dead, or whatever the story is. You go through and you say it's in the child's best interest to be with mom or aunt in the U.S. because either they perpetrated the abuse or it happened in their home, and you eliminate it that way. That's one of the ways you can get to it not being in their best interest without even getting into the gang violence and the custody. And so to the extent you can do it within how you're adjudicating the custody determination, it's best to do it that way, and then you can add the gang stuff if you'd like, but relying only on the gang stuff gets complex from the DHS perspective because then they start wondering what you were up to. you know, but if you do it based on just the kind of best interest of the child factors, and again, this is another place where the best interest of the child factors that apply to this are state best interests. It's the same ones you deal with all the time. Okay. We talked about this. Oh, the one thing I will mention, this came up in some training in Virginia, and I don't know, in custody cases, sometimes, you know, the child may have traveled here, and the question is, how do you get jurisdiction in the custody case under the UCCJEA? And many of these cases will start as emergency jurisdiction cases, based on the abuse, or the domestic violence, or whatever. And so it will be your UCCJEA procedures, the interstate procedures that would apply. And some of these you're not going to have, the home state's Guatemala. Right, so you're going to have to figure out and go through. So you can go through, you're not precluded from bringing the custody action. You're not forced to wait the 6 months because you can do it through emergency jurisdiction if it qualifies under state law. And that Congress essentially when they set this up for state court judges, they did it to, they didn't want the DHS adjudicators to be the ones to decide abuse, abandonment, and neglect because that's not their area of expertise. State court judges do it all the time, and so they were deferring and kicking that to state court judges because that's what state court judges do. And they were looking for a mechanism as they moved these cases to be broader than the foster care system to have, you know, to put it in the hands of people that do this as part of their daily jobs, essentially. And again, the SIJ findings, just like the U visa certification, are evidence. They are not, I mean, DHS will take this order and your findings, which are findings in your case, and look at your findings here and consider that, but it doesn't automatically mean you're giving the child SIJ status. They have to prove their eligibility to DHS, and DHS has to decide to essentially consent to it. And so this describes a little bit about the federal roles. I mean, the state court is deciding the placement, the dependency, the custody, the abuse, abandonment, and neglect, and then DHS is looking at, like, they'll look at the criminal history of the child. They'll look at the evidence, the entire package of evidence before them in deciding the case. And they're going to decide whether they think, and this is where the details of your court orders are important, DHS is going to decide whether they think the child did this only for immigration relief, that there wasn't any legitimate custody or guardianship purpose. Yes?
If we're identifying a child
Hold on one second.
You hang on, Mark.
I'm sorry.
I'm coming.
Sorry. Thanks. Sort of getting back to what I asked at the beginning, but if we're identifying a child who might be a good applicant for SIJS, and it's a delinquency matter or what we call a PINS matter, a status case, based on what you're saying, we would need to actually have the parent file the custody and perhaps join it?
No, they can do it you can make the SIJ findings in dependency as well, and in PINS.
So how, when you talk about custody and placement, a lot of times we'll have one child, one parent, and assuming we have the other criteria, we would be asking our PINS judge to make the custody or placement decision within the delinquency case, or
yes.
I'm sorry, status
if you
case.
can under state law, yes. So what they would do is, let's say you have the other parents abandoned or abused and they're in Guatemala, El Salvador, Honduras, wherever, and they're with mom here in the PINS case, they would be potentially placing the child with mom as part of the PINS case or as part of the delinquency case, and that would be sufficient.
Okay, thank you.
Yeah. And we do have one of our expert national judges is sitting on the delinquency calendar in San Francisco. She's doing tons of these, and if you're in a delinquent, if you're a judge or in a delinquency proceeding, and even if you're a lawyer, I'm sure Susan Brio would be happy to answer questions on this as well. Okay, so anyway, these are some of the reasons, some of the historical background of why they chose state court judges is here. And that the kinds of kids that are potentially eligible are any minor who's abused, abandoned, or neglected in the U.S. or abroad, They could be living with a non-abusive parent. They could be living with a guardian. They could be, living with an aunt or uncle, or a next friend. They could be the adoptive parent. They could be in state foster care. They could be in federal foster care. I don't know if you guys are seeing the federal foster care cases here. There's certain places where they are. Okay, those are particularly complex, actually. But they use declaratory judgments in those cases to get the kids into court, because the federal foster care won't bring the kids to court, so there's nowhere to get them. So the kid has to file a declaratory judgment as the way to do it. So it's complex. So kinds of proceedings are all of these. There's any kind of proceeding where there's jurisdiction over the child, divorce, custody, adoption, separation, guardian.
Ms. Orloff, 1 minute. We can't hear you back here.
Oh, sorry. I ran out of juice. Oh. I'll give you this. And I'll switch to this. Okay. Hello? There we go. I scared myself. So anyway, it's any of these kinds of proceedings. Declaratory judgments are available in almost all states, DC is included. Many of these, just so you know, many of these kids will come in at 15, 16, 17-year-old cases. They have a deadline of filing by the time they're 18. And some of the reasons for that has to do with the process of immigration. So they'll get here if they got picked up and put picked up by the Department of Homeland Security and put in HHS care. HHS then tries to find family members to release them. That release is going to become much harder now, because even before this administration, what was happening is that, generally speaking, parents might be here, but they were afraid to come forward. They were undocumented. So they'd release them to the church, or they'd release them to somebody else as a sponsor, not the parent. And thank you. And now that's even worse, potentially. So you could see even greater delays in kids coming in later because they're stuck in federal foster care until they can find a place, in HHS care until they can find a placement. And that could get harder. So it is one or both parents. There was a lot of confusion about the law. And part of the reason there's confusion about the law, I'm a law professor, I love these kind of slides. Long and short of it is, in immigration law, and in this area in particular, but it's not only here, you have, and this is hard to do with a microphone in my hand, but you have a statute, then you have a set of implementing regulations, then you have another statute that overruled the regulations, and you have no new regulations. So that's the state of immigration law in many, and it's certainly true in SIJ, and in VAWA petitions. There's a lot of places. So what was happening is that you had these appellate courts in New Jersey and Nebraska and all these places that were trying to interpret the two together. They were trying to use the regulations to essentially overrule the subsequent statute. Long story short, one parent. You don't need both, no matter what anybody tells you. That's the law. It has the regulations. If you send your law clerk to look at it, will say something else because they're old. That's the problem. So that happens in immigration law all the time. And so look at the statute first. Then if the regulations are inconsistent and you're confused, call us. We do technical assistance on this all the time. We'll give you the case law. We'll give you DHS policies and help straighten it out. Okay, and I talked about the details of the order. So what SIJ kids receive, now going a little bit into the benefits. The moment they file, they get some protection from deportation and removal because the case is pending. How meaningful that will be in this day and age is unclear. But generally speaking, once a case is filed, it's easier to get enforcement officials to back off. And in SIJ cases, unless you're talking about the cases happened here where you've got an active domestic violence perpetrator, for example, trying to get the kid removed, then it may not be an issue. The child is considered, so really important, from the moment, well, in DC, undocumented children and crime victims and everyone gets access to health care through DC state-funded health care. In other states, or you might be dealing with states from other, people cross the lines, I have no idea, but generally speaking, as a matter of federal law, children are eligible for the health care exchanges without subsidies the moment they file for SIJ. Subsidies come depending on the state. There are subsidies in DC. And they get services necessary to protect life and safety, which I'll be talking about in a few minutes. At approval, they get an ability to apply for lawful permanent residency. They usually file concurrently. It's 2 separate proceedings. They get legal work authorization. They get federally recognized driver's licenses. They get post-secondary educational grants and loans for college. They get access to public and assisted housing. They get food stamps until they turn age 18, but they never can file immigration status for a family, for a parent, even the protective parent. So they can only, so SIJ will cut off, they can't sponsor their parent later on, even the protective one. As to the delinquency issues, you had a question before. I just want to point out that juvenile delinquency dispositions and findings are not convictions under immigration law for SIJ purposes, but they can have consequences. So if you have a juvenile disposition, they can be used as a negative discretionary factor in the SIJ case. DHS will know about them. They take fingerprints. They see everything. It's DHS. So records being sealed, schmealed, whatever you say, theoretically it's true, but they see everything. And they consider it. So it's important to know. Yes. Oh. Hold on one second. She's coming.
Sorry. It's all right. I was due for a walk.
Well, then, do you know whether or not in the Rule 11 plea colloquy in juvenile, when they take a plea, whether or not we have to admonish them of this? Because I know in the adult cases we do. Maybe
It'd be the same. I think it's the same. I mean, I would apply Padilla in the same way on all of these cases. Even though theoretically there are exceptions, the bottom line is DHS sees arrests. They see everything, and so it's just going to be clearer for them to have to go through with their attorney, because they may plead differently. They may decide to make a different set of decisions if they think they're going to qualify for immigration relief. And this is the SIJ ineligibility. Other forms of relief have different exceptions. And there are certain grounds of it. The bottom line is there are certain offenses that, generally speaking, are never waivable, and certain that are. So, and for SIJ, prostitution, drug abuse, or addiction, or smuggling are waivable. Drug trafficking is not. So drug crimes that are more than possession, that are dealing, or all that stuff is not waivable. And certain crimes of moral turpitude, theft and shoplifting are big ones. They're in terms of non-waivable offenses. Now, this is criminal offenses. So what would happen is in the juvenile delinquency, if you have a juvenile delinquent that's shoplifting, you have a juvenile adjudication of shoplifting that is waivable because it's not a conviction, because it's a delinquency finding. DHS is going to see it. Their lawyer is going to need to explain it, but they'll still be able to get SIJ. If you try them as an adult on shoplifting, they're out of luck. Okay, I mean, and the reason it's shoplifting, this is the one that drives me nuts, because think of all the battered women who shoplift baby food to survive, right? What happens is under federal immigration law, it's considered an aggravated felony under immigration law is any conviction in which that involves like theft, fraud, or whatever, in which they received a sentence of more than 365 days. So a year suspended is a federal felony, is an aggravated felony under immigration law, which is how the shoplifting stuff comes in. Very complicated stuff. We can get you on these things in touch with immigration experts on these. It's really important to talk to an immigration expert on these cases. Okay. So this is the same. I'm coming back to this because I just want to talk finally about the 3 forms of immigration relief that you'll also see. I want you to recognize what they are, but there's no court role in these cases per se, except for that your findings in the court case can be helpful in the immigration case. First one is battered spouse waiver. Under immigration law, federal immigration law presumes all marriages are fraudulent, unless proven otherwise, basically. They presume that everybody's only getting married for immigration relief. And so the immigration law is structured to make so if I get married, my husband, if I'm sponsoring my husband, I file immigration papers. If on the day that I have my interview with DHS to show them that this is a legitimate marriage, we're married less than 2 years, my husband gets a conditional green card and then has to come back with we have to file a joint petition with DHS 2 years later saying, see, we're still married, and proving that it's legitimate. Well, that traps people, battered immigrants, for example, in that relationship. So first form of immigration relief created under immigration law was the battered spouse waiver that allows somebody who's the spouse of a U.S. citizen or lawful permanent resident, where they filed papers for her and she got a conditional, he or she, it's gender neutral, got a conditional green card, to get a full green card without they have to show domestic violence, battering or extreme cruelty, and they can get a full green card without the perpetrator's knowledge, consent, or assistance. So it's got VAWA confidentiality, they can file, and they can they basically come in and prove the domestic violence and prove that the marriage was legitimate, and they get their full green card and are free to go, essentially. Easiest kind of case for victim advocates in the room to prove, don't need an immigration lawyer. We help victim advocates do it all the time. Family lawyers, you guys can do these too. If you can prove domestic violence, you can prove what you need to do for battered spouse waiver cases. VAWA self-petitioning. That's the next to U visas. This is the biggest category of cases you'll see in the courts here. Prosecutors, you may have VAWA self-petitioners as well. It's important for them to start their immigration cases just like the U visa cases. You'll have the same arguments that she filed just for the papers. You know, she learned about VAWA. You'll have the same prior consistent statement issues that you can bring in on these just like U visas. But who qualifies? It's somebody who's been battered or subject to extreme cruelty by their U.S. citizen or lawful permanent resident spouse, former spouse, they have 2 years from divorce to file, parent, step-parent, they have to file while they're still alive, step-parent relationship, no 2 years on the step-parents. Or elder abuse cases, you have cases where a U.S. citizen's son or daughter could file immigration cases for their parent. And you see a lot of these in D.C. Like they bring grandma over from China and hold her hostage to take care of the kids. You might see those kinds of things. They have to have resided together for some period of time. No specific number of days is required. Even an overnight visitation in a custody once is enough. It's just some time, some period of time they resided together. They have to be people of good moral character. Anybody know how DHS defines good moral character? What are they looking for primarily? No arrest. Fingerprints. They're going to be looking at criminal records. You can prove, if you have an arrest or a criminal record, you can potentially get around it. It's harder than a U visa. And sometimes victims who qualify for VAWA will have to file a U visa if they have criminal histories. And you have to show that the marriage was good faith. And a good faith marriage, basically, if one of the reasons we got married is so I can get immigration papers, that's okay, as long as there was a legitimate relationship and a marriage and whatever. And so those of you sitting in protection order courts may see people come in and say, I want to get all the love letters out of the house. Why would they want those? They're fighting. They want them because they're evidence of a legitimate relationship and a marriage in an immigration case. So love letters, wedding photos, photos from trips, things that show this was a real marriage are the kinds of things they'll do. So what do VAWA self-petitioners get? So these are all cases where the abuser is the U.S. citizen or lawful permanent resident, and it's a spouse, parent, or child, step-parent, or former spouse. And when a VAWA self-petitioner gets, when she files she gets protection from deportation soon after filing from this computer system I was talking about. She gets benefits, immigration benefits for herself and her children. U visa victims can include their children as well. She's a qualified immigrant, big difference. VAWA self-petitioners are considered qualified immigrants for public benefits purposes. U visa victims are not. Big difference between the two in terms of public benefits. She and her children get public benefits. I'll talk about what those are in a little bit. They get work authorization. It takes about 6 months to get work authorization, or shorter if their abuser is a US citizen. They'll get work authorization within under 12 months if they're a lawful permanent resident. So it's different. They have to wait for their time in line. So they get their case approved, and then they have to wait in line for the visa to become available. For the, and so that waiting line can add a little bit more time to those cases. They get VAWA confidentiality upon filing, and then they get lawful permanent residency immediately. They can file if they're married to a citizen. They have to wait 3 years to file if they're lawful permanent residents. If their abusers are lawful permanent residents. But they have work authorization and all of that. So they can't travel back and forth out of the country easily. Nobody can. And those of you that are victim advocates and attorneys should not be recommending that your clients leave and come back into the country, because re-entry into the country can trigger all kinds of immigration bars and problems. I see immigration attorneys. Big problem. Okay, trafficking. Trafficking was one of the crimes on the U visa list, but also victims of severe forms of human trafficking have access to the T visa and continued presence. Much more robust in terms of the public benefits people get. So there's severe forms of human trafficking are defined as labor trafficking, which is recruitment, harboring, provision, or obtaining a person for labor of services through force, fraud, or coercion for the purposes of involuntary servitude, peonage, debt bondage, or slavery. So you have to have force, fraud, or coercion, and there has to be some end. And that related to, coercing labor or economic benefit, etc. Sex trafficking is a commercial sex act induced by force, fraud, or coercion if the person is an adult, or performed by a minor under the age of 18, in which case you don't have to have force, fraud, or coercion. Try to switch clicks. Continued presence is a temporary lawful immigration status that victims of severe form of human trafficking can get. As I explained earlier, it has to be filed by federal law enforcement officials. State and local law enforcement officials can request that the federal officials seek continued presence on behalf of the victim they're working with. The benefits of continued presence are a temporary legal status in the United States, work authorization, full access to public benefits, just like refugees. Family members can come and join them. They can travel within the United States, but it does not lead, as we talked earlier, to lawful permanent residency. T visa, to qualify for a trafficking victim visa, survivors of human trafficking who is or has been a victim of a severe form of human trafficking, they have to be physically present in the United States on account of trafficking. Now, that doesn't mean they have to cross a border. So this is one area of a lot of confusion. Somebody could have entered unlawfully by themselves and then ended up being trafficked. They could have been, the trafficker could have brought them across the border, or they could have, entered unlawfully and went to get a job in what they think is a waitress in the bar and end up in a human trafficking situation. So it's whether or not their movement is restrained by the trafficker in any way is how you get at the essentially their restriction being that they're being physically present on account of the definition. So it's a good definition in the regs. They have to have complied with any reasonable request for assistance in the investigation or prosecution. So this is different. This is not detection, investigation, prosecution, conviction, or sentence. That's one difference between T's and U's. And they have to, the unreasonably refuse to cooperate isn't the same in trafficking. You have to have it has to be reasonably requested, but if they can show they would have suffered extreme harm, if they can show that there were severe emotional consequences, there's a way to get around the requirement for cooperation in the trafficking victim visa. And they have to show that they would have suffered extreme extreme hardship involving unusual and severe harm upon removal from the United States. That is the provision that forces many trafficking victims into U visas. So what happens is that some people might be trafficked and they meet all the other criterion, but if you think about the Canadian student who might end up somehow coming over here and end up in a trafficking situation, or where they could theoretically go home, it's hard to show severe harm upon leaving, that's where some of these trafficking victims end up with U visas as opposed to T visas. T visas get the best benefits, the most benefits. They get protection from deportation upon filing, VAWA confidentiality protection, necessary to protect life and safety services. Upon receiving a bona fide determination, in the T visa case, they get all federal public benefits, access to the healthcare exchange, work authorization, driver's licenses, and upon approval, they get immigration benefits for their unmarried siblings, and it's quite broad, lawful permanent residency after 3 years. The other thing, the last form of immigration relief I want to talk about is DACA, which is Deferred Action for Childhood Arrivals. This is for children who were brought to the United States who are under the age of 16 when they were brought here. They resided for at least 5 years from after June 15, 2007 to the present time. And they had to have been physically present on June 12, 2012, in high school or graduated, honorably discharged. And this is where, again, these convictions become an issue for DACA, as well as, juvenile adjudications, convictions, adult convictions, things like that. It's a similar kind of thing in terms of as SIJ. The issue is, and they have to have been 30, they have to apply before they turn age 31. So what's really important here is that kids who are DACA, who might have DACA, they have temporary status. It doesn't lead to anything permanent, and if they end up being crime victims, they should be pursuing VAWA or U or T, because that gives them a path to permanent residency, or SJI, that DACA doesn't. Okay. Family court. Whew, I just take a breath for a second. So what I'm going to do in this next section is talk about how these, I've gone through the statuses so that people can recognize when a case is before you in family court, or if you're an advocate or attorney working on a family court case, victims who would qualify for immigration relief. Because pursuing the immigration benefit can help your family court case in a variety of ways. But also there's a lot of misinformation out there. So let me just start with jurisdiction. Hopefully you're not seeing these problems, but we've seen them around the country. So the jurisdiction, the state courts get jurisdiction in the same way as they do in any other case. Protection order jurisdiction is going to be based on whether the victim has fled here or the crime occurred here. Divorce jurisdiction is going to be based on residency of a party in the state. Has nothing to do with lawful permanent residency. FYI, I don't think I included this case, but especially in DC, you'll have people who work for, let's say, the World Bank, where they're telling, so the issue here is if they're claiming to not have DC residency, to be a foreign resident, not taking residency in DC, so that they can get they'll pay for their kids' schooling and they'll get health care benefits through the bank and stuff like that. They can't claim foreign residency for purposes of avoiding U.S. taxes and getting all those World Bank benefits, and residency in D.C. for divorce purposes. You can't have both ways. And there have been case law on this. It was actually a Virginia case where they were trying to claim both. They were trying to get residency for divorce in D.C. in Virginia, but avoid Virginia taxes, and you can't do it. But you don't need, it doesn't have anything to do with immigration status. It's the same residency laws that apply to anybody else. Same thing in custody and guardianship, child abuse and neglect, child support. Same laws apply. Immigration status isn't the issue. So impact of divorce. So divorce is not benign when you're talking about immigrant families. VAWA self-petitioners have 2 years from divorce to file, so if you divorce, it starts a clock running, and so she needs to learn about the VAWA immigration relief, or she loses her ability to apply, or ends up only being able to apply before an immigration judge, which could be risks deportation, which could be complex. Spouses and children of visa holders control the immigration status of their spouses and kids. So if I am here on a work visa, I control filing for my kids and my spouse, and so if there's a divorce, then they get kicked off their visas, potentially. So that's an issue to be aware of. The other thing that's really important is, and sometimes perpetrators, particularly of domestic violence, will do this. If I'm a lawful permanent, if I'm applying for, let's say I have a work visa and I'm applying for lawful permanent residency, and I've included my children and my spouse in my application, if I get a divorce the day before I get my visa, my spouse gets nothing. If I get a divorce the day after I get my visa, my spouse is a lawful permanent resident. So you could see odd things happening in family court where people are trying to play a game with this. And it's just be aware so that you can, decide, just be aware that that's happening and that there's reason, that may be part of the pattern of abuse you're seeing in the case generally. But litigants do this. The other issue is divorce. Sometimes people will come in and apply for annulment instead of divorce. So you'll see a case where they've been married for 10 years and they have 3 kids, and he's coming in applying for annulment. It's like, what's up with this, right? And they're doing it because he's trying to undermine her access to immigration relief based on the marriage. And so, but it's not benign. The parties might say, well, fine, we'll just agree to the annulment. I just want to end the relationship. And they say they're going to work everything out. But the trick is, if she agrees to the annulment, and they say, then he can turn around and use that with federal prosecutors for marriage fraud. And they do. So it's important, if it would normally be a divorce under state law, to go ahead and do the divorce and not do the annulment when it wouldn't normally be an annulment case. Okay. Custody. Are you guys holding up okay, everybody? I know I'm covering a lot here. Okay. So, as to custody, I want to start off with, again, some data. One of the things we looked at, and we looked at immigrant victims of domestic violence seeking help through VAWA and the U visa and other kinds of forms of immigration relief, and also protection orders. We looked at a group of victims nationally, and what we saw was that in these cases, protecting mom really did protect the kids. Protecting the non-abusive parent really had effects for the kids. And what we saw was dramatic drops in the co-occurrence of child abuse and domestic violence in families where the victim was a help seeker, where the immigrant victim had found her way to either immigration relief or the protection order for it. And that in those cases, the children, we saw a 20% drop in the likelihood of having the children threatened by the abuser, and we saw a third less threats of parental kidnapping and things like that happening. So they really, really did work when victims found the courage to come forward and use the court system. It really did work to help protect them. So back as far as 1991, the ABA Commission, Center on Children and the Law, opined on this whole issue of raising immigration and custody status in custody cases. And what they said was, the parties shouldn't raise and courts shouldn't consider the immigration status of domestic violence victims and their children in custody, divorce, and child support proceedings, so that batterers weren't able to use threats of deportation and that kind of coercive control in the family court case in cases of immigrant victims. And then the children would get the same protection as any other child, let's say in DC, would get under different state laws that have either presumptions against awarding custody to abusers or evidentiary rules and things like that, that the kids in immigrant families, that 24% I was talking to you about earlier, would get the same benefits as any other child if immigration status wasn't raised in family court proceedings. However, we've evolved a little bit since then, And so it's a little bit more complex than we thought it was back in '91. And that is that immigration status might be relevant for the victim to raise in her own case to show part of the pattern of abuse. So we don't say anymore it's totally irrelevant. What we usually do is advise judges to kind of look at who's raising it about whom. You know, is somebody raising it as part of their own case about their own status as part of describing the pattern of power and control and abuse in the relationship? So it might be relevant to immigration-related abuse, power and control evidence in a custody case or a divorce case. It might be relevant. There might be evidence of, you know, he never filed papers. So going back to the video, he tore up the papers. He refused to file papers. It might be evidence of the pattern of abuse in the relationship or the history of violence. But it's not relevant, and it's never been relevant, to the core primary caretaker determination. So it's not relevant to, you know, who's been the primary caretaker of the child. You know, how do you evaluate the parenting skills of both parents? Particularly in DC, you're lucky because driver's licenses aren't an issue. And in some cases, courts will get all wrapped up in the fact that she can't drive legally. Here you can get a driver's license when you're undocumented, so that issue goes away. And that it's not relevant to the requirements of custody or, you know, of the state laws or the laws of the District of Columbia regarding, you know, how courts evaluate abusive parents versus non-abusive parents in terms of custody. So some of the myths and facts, and this comes out, remember, I think earlier I talked about, we looked at case law nationally, reported case law nationally. And what we found was there were a number of things that we saw as patterns that were happening in state court cases and family court. The perpetrator, or I'm a domestic violence lawyer, so I always say perpetrator, but the non-custodial parent will come into court and argue that because they're undocumented, deportation is imminent, which isn't true. If they're crime victims, it's definitely not true. So if you've got a case where the person is a victim of domestic violence, sexual assault, human trafficking, any of those U-Visa criminal activities, it's not true that they're going to be immediately deported. The other thing is even in this day and age, if there's somebody, so who are the people at most danger for deportation in today's world of reality, our current reality? Anybody with a criminal record? So immigrants with a criminal record and immigrants with open deportation orders. You know, if they're in a proceeding before an immigration judge, it doesn't mean they're going to be deported. The deportation is usually stayed while the immigration court case is proceeding. But if they've had a deportation order in the past, then those are the two groups that are where there's some imminence. And that when you're dealing with crime victims and abused, even a protective parent who wasn't abused themselves, if they're actively involved in helping their child, let's say, participate in a sexual assault prosecution or participate in a child abuse case or something like that, that parent is protected because they could qualify for a VAWA or a U-Visa. So there are DHS, you know, statutes. There are statutes in place that, so don't be tricked into thinking that deportation of anybody who's undocumented is imminent. The next thing is that they think that the parent who's undocumented or doesn't have legal, the parent with the least permanent immigration status is likely to flee the country. Think that's true? Who's more likely to flee? The one with more permanent status. Exactly, because they have entry and exit visas. They can come and go as they please from the United States. And in fact, there's really good State Department data on child snatching and foreign-born parties. And what they find is that the person, it's often the person with lawful permanent residency or a person with dual citizenship, or you know, the person that comes back and forth for work that's most likely to snatch than the person that's here. Because since 1996, people who are undocumented who leave the United States, like if you stay in the United States and let's say someday there's legalization or you're eligible for VAWA or a U-Visa, if you stay in the US, the rules that apply to you in terms of getting a permanent visa are less onerous than if you leave and re-enter. Upon re-enter, it triggers these 3- and 10-year bars and all this other stuff, which is why nobody leaves. Do you have a question? No? Okay. Okay, where am I? So the other thing is it's not true that the parent has no livelihood, right? So they might argue that I should get the child because she's a non-citizen and I can work legally, and she can't. I'm a citizen and she's not. Actually, child support works in the same way. You know, you can order child support to help remedy that. It's also important to look at whether she's actually working. So you have, how many of you that are advocates or attorneys have worked with immigrant clients who are undocumented and working? Everybody, right? I mean, there's lots of clients, and in fact, immigration law is structured so that undocumented people can pay taxes. There's a tax ID number they can get. And it's structured so that if you're undocumented and you apply through VAWA TRU and you get a work visa, you can, like, even if you were using false papers, you can switch them. So that, you know, IRS wants to collect its taxes. And immigration law is structured so that people who are working, even undocumented, have an easier chance to get lawful permanent resident than people that are not working, because they can show that they're self-supporting. So there's something called public charge that applies to immigrants generally when they get lawful permanent residency and citizenship. Victims, VAWA Ts and Us, are exempt from public charge so that they don't have the same, they don't have to prove their ability to support themselves in the same way as other victims. Okay, and that the other one that comes up a lot, and we have a giant chart in our materials on our website where you can look up. So another thing that you see in the court cases is the non-custodial parent will say, I should get, or a parent in a custody case would say, I have to have custody of the child in order to sponsor the child for immigration relief. And it's just not true. If they can sponsor the child for lawful permanent residency, having custody is not a factor in the sponsorship. So we have a giant chart where you can look up the immigration status and whether or not that person has to have custody to sponsor. And there's one small case that has to do with kids born abroad where they should be in the custody of the parent at applying. But it's almost not what you're going to see here, and it's in almost all cases they can sponsor them whether or not they have custody. It's irrelevant because it's about the parent-child relationship. So that was the points I had on custody. Are there other, I mean, those of you from Legal Aid or anybody, any questions about custody? Next thing I'm going to talk about is dependency and termination of parental rights. So first thing, kind of going back to immigration enforcement, it's important to understand how parents end up in Department of Homeland Security custody, how they might get, what might trigger them being kind of turned in. And we talked about this. It's abusers, perpetrators, traffic stops is the other one, where people, particularly in jurisdictions where they're driving without licenses. And then there can be worksite enforcement. But the other thing we've seen historically is hospitals, child and adult protective services turning people in. And then the other thing that can happen is where language access isn't provided on the scene of the crime, you can get dual arrests, or you could get the victim and not the perpetrator, you know, the person who's not the primary perpetrator of the relationship, of abuse in the relationship being the one that gets arrested. And so what I want to do is I'm going to tell you briefly, and this is as much a language access story as anything else, but this is the case that essentially created the primary national precedent, both in terms of the Nebraska Supreme Court decision that I'm going to show you in a minute, and in terms of DHS policies about parents and dependency and parents' involvement in custody cases and dependency and delinquency, or dependency and termination right cases. So this was a case in which Maria Luis was a Quiche-speaking Guatemalan mother with 2 children. Her daughter was born with respiratory problems, and she was in Nebraska, and she went to the hospital in Nebraska to get her youngest child treated with respiratory illness. She went to the hospital and they gave her a Spanish language interpreter. She didn't speak Spanish, she spoke Quiche. From what she could understand, she thought, what she understood when she left is if her daughter didn't get better, they gave her medicine and stuff, if her daughter didn't get better, she'd come back to the hospital. What the hospital claims they said to her is, if you don't come back on such and such a day, we're going to turn you into DHS. We're going to call child CPS. And so her daughter got better, and she didn't go back to the hospital, and the hospital called CPS, and CPS went and got a law enforcement officer. They're dressed in a uniform. They go to her house to pick her up for not bringing her daughter in. She's terrified. She sees the uniform. She thinks it's DHS. And she lies about being the mother. She says she's the babysitter. So then they arrest her, take her into custody, turn her over to DPHS, take her kids, put them in foster kids, and then while she's in DHS custody, they serve her with a notice in Spanish, in DHS custody, to come to court on the dependency case. To, the case, against her, the abuse and neglect case. She loses her custody of her kids. They give her a parenting plan in Spanish. It's issued after she's deported to Guatemala. So all along the way, there's like no language access, right? No language access in the court proceeding, no language access from DHS. Long story short, and then then the people who had her in foster care want to adopt her kids, and they terminate her parental rights. So this is Nebraska. And ultimately, she finds her way somehow to MALDEF, who finds their way to us, and we do an amicus, and they represent her. 3 years later, she gets her children back. Unanimous decision from the Nebraska Supreme Court that's relevant not only to termination of parental rights cases, because the standard it elicits is based on the Constitution, it also affects custody cases. And essentially, basically, it says that undocumented parents who are undocumented, in detention, or deported have the same constitutional rights here, if they were here with their kids, to custody and the findings of unfitness that would be required to separate them from their children as anybody else. The children and the parents have those rights. It applies to all families without regard to the detention, deportation, or undocumented status of the parent. There's an overriding presumption that the parent-child relationship is constitutionally protected, and it's in the child's best interest to stay with their natural, non-abusive parent and be reunited with them without regard to where that is. Because what the Nebraska trial court did is they compared whether they thought these children would be better off being brought up by essentially strangers in America compared to their mom in Guatemala. And the Supreme Court said it is not a comparison of countries or cultures that the court should be entering into. And so in the end, this case caused the Department of Homeland Security to create something called the Parental Interest Directive. And for those of you, we have a brochure on essentially if parents are into detention, how do you get them to court? How do you get them involved in the proceeding? So we have a brochure. There's instructions for advocates and attorneys, but there's also separate instructions of who your law clerk can call to get them brought up to the court proceeding, or to get them to be engaged in the court proceeding through, electronically if there's not a way to bring them here from detention. And so the directive requires detention or placement of the children, if the parent is detained, near the family court or where their children are. It gives parents, and it requires them to be brought to court to participate in any kind of proceeding regarding their children's dependency, delinquency, child abuse, protection orders, divorce, custody, anything that has to do with their child, where their children are going to be involved. And in fact, they will, DHS will allow parents time before removed from the United States to get the passports and things like that so their kids can come back. And they will bring deported parents back to participate in court proceedings. The lessons learned from the Maria Luis case is, it's really important to have language access. Parents can execute powers of attorney that try to help, if in fact they get picked up, it gives them direction about what will happen to their kids while they're in detention. And the role of counsel or notification, and it's important for courts and advocates and attorneys to know this. Like, for example, the Mexican consulate will pay for counsel for people, Mexican, Guatemalan, they'll pay for counsel for their citizens in some of these cases if they're notified. They'll get involved in trying to help in various ways and even work with DHS in various ways. So it's important to notify them. We have, we have information on where you can get accurate information. The long story short, Maria Luis got her kids back. DHS gave her a humanitarian parole, and she was able to remain in the U.S. for a year or so while she reunited with him. She'd been separated from an infant and a 6-year-old by the time she got back. And then they went back to Guatemala, and her son is actually now in starting college in the U.S. So anyway, so that's the piece on dependency cases. Okay. Sorry guys, I know this is long, but we're going to go now into protection orders. I'm going to talk about how it worked for them and how it worked for them. And we basically found that despite the fact that 60.9% of victims who walked into domestic violence programs or shelters or legal services agencies for help with domestic violence had no idea what a protection order was when they walked in the door. With good safety planning and victim advocacy, 81% decided to get protection orders. And there was a direct relationship between the level of violence and their willingness to get protection orders. The more violent it was, with advocates and attorneys' help and safety planning, advocates and attorneys were able to convince victims to actually go seek protection orders, despite the fact that they were afraid of the court system and all of that. And 96% of them found it helpful. But in the data, in the 6-month follow-up we did, we found a dramatic actually drop in the physical violence stopping, but not the emotional violence. The emotional power and control continued, and immigration-related power and control and threats continued. But the protection orders were effective in reducing violence in those cases. So there's a lot of misinformation out there about protection orders. So sometimes, like, abusers in protection order cases will say, I can't consent to a protection order because I'll get deported. Total lie, not true. Issuance of protection order has no effect on anybody's immigration status. Violation of a protection order, a finding of violation of a protection order is a deportable offense. And so it's really important to kind of understand that distinction. It's the enforcement stage where you have to start looking at deportation consequences. It's not the issuance stage. And that the immigrant victims need creative remedies using the catch-all provision. And DC has great law on this. It goes back to Powell versus Powell and all of that kind of stuff. And so it was one of the first states in the country, jurisdictions in the country, to really begin to define how the catch-all provision in the protection order statute could be used. What harms, if any, do you see? I'm going to try and ask some questions here and see if we can get people, try to wake you up a little bit. What might happen? Why is it a problem potentially if a battered immigrant got a protection order issued against her? Yeah. Anybody? Dangers, problems?
Sure. We have one judge up.
Yeah.
Is this
Yeah.
on?
Yeah.
One of the issues would be that the abuser, the true abuser, might be able to use the criminal contempt process to exert power and control and also falsely report things and create power and control and criminal findings against the actual victim.
Correct. Yeah, that's one of them. Yes?
Also, it makes the real victim even more it doesn't trust the court even more.
Right.
Like already they feel uncomfortable navigating the court system, and when that happens, usually
Right.
causes a chilling effect on the actual
Exactly.
victim.
Right, and it reinforces everything he's been saying to her, yeah. Other people? Anybody?
That question was answered, was asked already, the one that she had.
Okay. So, right, it increases the perpetrator's power and control. Perpetrators, and the other issue is because violation of a protection order is a finding of violation of protection order is a reportable offense, if he can convince her or the court or her counsel or somebody to agree to issue a protection order against her, it puts her one step away from deportation. And that's really, in this day and age, a big issue. And so, if he's successful in getting her to agree to have the order issued against her or convincing a court to issue it against her, then he may be very likely to be successful to show that she violated. And that's a big problem. And so there's serious safety concerns. The typical ways that immigrant victims could end up as defendants in protection order proceedings, the most typical way that it happens is sometimes the police will arrive on the scene. If they don't get a qualified interpreter, again, particularly in languages that are not English or Spanish, and the perpetrator is the one who spoke English to the police may end up arresting both of them or telling him to go get a protection order against her. And then the outcome is that, and that what may happen is the victim will then learn about protection orders because she's served with the protection order that he seeks against her, and then will come to seek her own protection order. The other way is, the police may convince, the perpetrator may convince the police to arrest the victim instead of the perpetrator at the scene. So it's really important, again, there's a question. Hold on one second.
Where am I going?
Is any violation of a civil protection order that results in a criminal contempt conviction a deportable offense, or does it have to be like an assault or a violation against the petitioner?
Excellent question. So it has to do, so it depends on your criminal contempt laws, but generally speaking, it's a violation of what in the immigration law talks about as the protective provision. So failing to return the child from custody, a visitation on time, no. It is, it's violation of the stay away. It's further acts of violence. It's that kind of stuff. It's not failing to turn over the keepsake from her mother, or failing to pay child support, or failing to repair the door of the house that you broke. Those things are not. It's the violence protection pieces that trigger deportation is the issue.
Thank you.
And then it would trigger it on a finding. So let's say you didn't have it's court counsel here, right? And there's a court counsel or the U.S. attorney who brings up protection order violation cases here.
Court counsel.
Court counsel. So if court counsel didn't bring the case and you did criminal contempt, but you went for criminal contempt for failing to pay child support or civil contempt, those things aren't going to be the issue. But if, let's say you went for criminal contempt and not the criminal case, and you got a finding that on or about such and such a date he assaulted her, then that finding, and even in a civil contempt case where he's not held criminally, whatever, any kind of finding, or even in a custody case, if they found that he violated the protection order, that's enough. It generally, as a practical matter, and this is one of those things we don't know, historically, it's taken the criminal case to the actual criminal protection order enforcement case to trigger deportation. But it could happen. The statute says upon a finding. And we just don't know in this day and age whether they're going to find a way to start enforcing those. So, yeah? Yeah, findings in protection order. Any finding about the violation of a protection order. So So the other thing is that, and I don't know to what extent I don't know how consent protection orders are working in DC now. I know what they used to be. But generally speaking, the other thing that's really important is that for immigrant victims is one of the things we see in these cases is perpetrators try to convince courts to issue protection orders without findings. What I mean by this is literally in some courts have a box where you could say no findings. Sometimes the judges will be convinced on consent to cross out they cross out the statute part and they say it's all by consent, we're not looking at finding. Bottom line is I actually got asked by my grant officers in the Department of Justice to do this research. Just like I can't walk into a judge and say, Your Honor, we don't meet the statutory, we haven't been separated long enough for divorce in DC, but divorce us anyway, we agree. You wouldn't do that, would you? You can't. Issuing a protection order where there's no findings is where you're literally amending the form in some way that you're not formally making findings is unenforceable because there's no jurisdictional basis for a protection order. So what I'm getting at, let me tell you what I'm saying and what I'm not saying. Issuance of a protection order by consent based on the uncontested affidavit of a victim in a civil case is fine. Okay? Because it's civil procedure, right? She complained under oath. He's not objecting. There's a consent. You're signing the normal form. You're totally fine. What I'm talking about is this comes up I don't know how much it's happening in DC anymore, but it comes up a lot in Texas. Why? Because they lose their guns. It's the gun stuff that people are trying to avoid. And so they'll cross out, they'll say, we all agree, so we're issuing the protection order, even though there's no findings. But the findings, you have no basis. So it's just important to be aware that perpetrators, particularly in cases involving immigrant victims, will raise this, and they're doing it in immigrant cases because they're trying to undermine the effectiveness of the protection order as evidence in the immigration case. Okay? That's why it's coming up. Have I been clear? So as I understand your consent system from the old days in DC, and I don't know, guys, if it's still the same, if the parties agree and nobody's amending the form and they're just agreeing that these are the remedies and it's by consent, that's fine because your protection, the jurisdictional basis for your protection order in those cases, the uncontested affidavit of a party in a civil case. So you're totally fine.
Even consent without admission?
So you have a consent without admission.
Yeah, that's what the majority of them are.
See, I actually think, so consent without, here's the problem. If it's, so the question is when you check consent without admission, you as the judge, okay, here's the issue. They come to you in consent and admission and the underlying pleadings in the protection order case say, on such and such a date he hit me, I got a cut, I fall, I called the police, blah, blah, blah. Then the question is whether as a matter of law, your jurisdiction to issue that order is based on her pleadings. If her thing is, I come home and he makes me cry every night, and there's no violence, there's nothing that would be enough for a protection order in the case. He just makes her cry all the time and she's upset, so she can't get a protection order. Where you wouldn't have any jurisdiction because there's nothing there's no intra-family offense. So that latter case, if the question is if there's by admission and you see the underlying facts in the latter case, you probably wouldn't issue the CPO anyway because there's no jurisdiction. So that's the issue. If without admission, as a matter of law, you're doing what I would do in a divorce case where I didn't have jurisdiction, because DC code says you have to have an intra-family offense. The question is, how are you getting to the intra-family offense for your order to be valid? And that's a problem. And it comes up when perpetrators violate the order, and it usually, the way it comes up is some smart lawyer says, wait a minute, this is without admission, so is the order valid? Where was the judge's jurisdiction for issuing the order? So that's what it turns on. So without admission might work because you still have to make an independent decision as a judge of whether or not you have jurisdiction to issue it based on what's before you. You're not doing it, you're doing it just based on him not admitting what she said. But you have to credit what she said. You know, if in fact there's not enough in it, or her, for some reason the petition is incredible, I mean, I think that's the issue. It's a tough catch, it's an issue. But it's something to be aware of. And I know courts don't like this because it's a lot easier to get them by admission, but the old way of doing it without that box, just by consent, was much better in terms of jurisdiction. Okay. So let me talk now about creative protection order remedies and then move into the benefits issues. So immigrant victims can really benefit from remedies that go beyond the regular checklist in the protection order proceeding. Catch-all provisions, Powell versus Powell in DC was the original case. I think it was Powell versus Powell, if I'm getting it right. It's a long time ago. And that as long as there's some kind of nexus, you have to show some kind of nexus between the remedy you're asking the court to give you and remedying or preventing the ongoing abuse or helping the victim heal from abuse. The kinds of creative remedies that courts will issue around the country in cases involving immigrant victims will often include remedies that are designed to stop the immigration-related abuse. And I'll give you an example that was actually the first judge to do it was a DC judge. I can't remember who it was at this point, but it was back in the 90s, 80s, 90s. But also to protect victims who are still living with their abusers. So this issue about, somebody was asking me about safety planning during that time where they're waiting for the case to be adjudicated. A lot of people use full contact protection orders where they're still living together, and it basically says do not abuse, abandon, do not molest, assault, threaten, or physically abuse, all of that, while they're living together. Those are perfectly valid and they're very helpful in these cases. They can use it to obtain documents the victim might need for an immigration case. There can be remedies that are designed to deter parental kidnapping, and then also child support and spousal support, and I'll be talking a little bit more about affidavit support in a minute. Health insurance is a big one. In DC, again, it's better because you can get subsidized health care for people who are eligible income-wise, who are undocumented, but without that, staying on the parent's health insurance is super, super important. So full contact protection orders are commonly needed, as I said, in cases of immigrant victims because of how long, even vola self-petitioning cases, it takes 7 months to a year to get the adjudication, and U visas are much longer, over 2 years. This is the order that people are using around the country, that a DC Superior Court judge came up with years ago, and basically ordering the perpetrator to cooperate in and not withdraw the immigration relief on the victim's behalf is one of them. But the more important one is you have to obtain prior court approval before contacting a government agency about the victim, either immigration officials, IRS, CPS, child welfare, except for police emergency or subpoena. And so that can be very, very effective. Back in the day, I don't know how many perpetrators I got, 6 month, whatever, 180-day contempt charges for violation of this provision. And it works, it's really important at times, particularly of increased immigration enforcement, to try to deter the immigration-related abuse if you see it in the case. Turning over documents, the kinds of documents that we use, so I mentioned some early, marriage certificates, photos, health insurance, evidence of good faith marriage, which would be birth certificates, love letters, copies of joint releases, school records, evidence of extreme cruelty or battery might be medical records, protection orders, those kinds of things. And then evidence of the abuser's legal status. So I've had judges, and judges around the country might order him to turn over a copy of his, or the copy of the number on his on his lawful permanent residency card or passport number or something like that, so that she can then have evidence to prove his status for volatile petition cases. Deterring parental kidnapping, super, super important because of the risk of international kidnapping. Yes?
Wait.
Sorry, I just wanted to go back to the catch-all provision about not reporting to any government agency without the court permission. So what exactly is the justification or the rationale behind that? I mean, you're basically telling the respondent you cannot speak to an agency. I'm just wondering.
There have been there's Supreme Court case. There have been constitutional cases around the ability of protection orders, in the context of protection orders, to order the perpetrator not to do things that he could legally otherwise do. So you're not controlling his speech. It's not about constitutionally controlling his speech in terms of making the call. You're controlling his action of threatening deportation-related abuse. So the courts, you can do it. I mean, it's not been, the appeals on this have been upheld, and that because the issue here is that he has. You're issuing these findings usually after a contested case, often after a contested case in which you're adjudicating the abuse, and you've heard lots of evidence of immigration-related power and control as part of the abuse. And so courts can order these, and there's not been any of them I've known nationally that have been overturned. Because it's not about, it's the same kind of thing. People in the early days, it was the early days of protection order law. If you look, I have a law review article on this from like 1993. Where it looked at the history of the constitutional challenges to protection orders, and a lot of them were these speech-related things. And they basically said, I mean, I don't have the case law in front of me, but essentially what they were saying is, just like shouting fire in a movie theater, right? You can't, or if the speech is part of a criminal act, they can be upheld. The right to free speech isn't. You can't use that to trump these kinds of protections where the court has a basis for issuing it as a preventive remedy.
And I understand that, but I mean, perhaps what the example I'm thinking of is a little bit different, but for example, in relationships where the respondent's knowledge of the petitioner's HIV status has been used as a threat to maintain that person as a submissive person in a relationship, and the courts have been reluctant to have a provision saying basically like you will not disclose the person's HIV status in Facebook or anything else, and it's seen as an infringement upon the respondent's First Amendment, even though it's basically like, okay, the civil protection order is again trying to protect this person, and the respondent's using the HIV status as a form to control them. And
have you appealed one of these?
Not to my knowledge.
Okay. I mean, because I would wonder whether on appeal it would still be, what happens at the trial court case is not necessarily what would happen on appeal.
Thank you.
Yeah, sure. And, I could, if you had a case like that, I could certainly give you the old constitutional case that, research that you could then update. Yes?
I have a question about the first point.
The first point on the last slide about an order forcing someone to cooperate with any immigration applications that had been filed. Have you seen that enforced in the sense of forcing somebody to sign a joint petition or to attend an interview or sort of?
Yeah, I mean, back in the 80s, we did it all the time.
Okay.
Yeah, I mean, that's all we could do because there was no VAWA or U visa. And so, yeah, I mean, he was ordered to do it, he didn't do it. And then, I mean, one of the cases I jailed somebody for violation of the protection order was that. And then they got out by signing. Because it was, civil contempt. So, but that becomes less necessary now because of VAWA and visas. So, there's lots of different things you can use in a protection order to deter parental kidnapping, turning over the passports, holding the passports in the court records, signing statements that, really important actually, you can get. I have a draft of this. It's part of a protection order where you basically can add a page where you're signing we used to use, I don't know what those forms are, the ones that you put everything else on when you're just adding findings. I can't remember the court number, but whatever. Where you basically say both parties and the judge would sign a statement as part of the court order that would say to the embassy, essentially, don't issue, we're asking that you not issue a passport or a visa to this child absent or this adult or whatever, absent court order. And those work really effectively to try to prevent international child snatching in cases where you have dual nationals or kids that, you know, need a visa to travel in the home country. And some cases they do it because under their law, it's the perpetrator husband, it's the male's signature. It's not the judge's signature that matters or the victim's signature that matters. It's his signature that matters under their law. And so it works. The embassy has to decide to pay attention. Most of them do. And so those can work pretty effectively. Economic relief is also super important, largely because victims can't work, as I talked about earlier, until they get legal work authorization, which can take a while under Val-1U visa. And so that can include monetary relief and things like child support, spousal support. And in the I'll talk about the economic stuff, turning over tax returns. So from an economic perspective, the thing to understand, and I'm going to speed up here because I want to get through everything before we're done, is that there are many kinds of visas where the spouse can't work. So they're totally dependent on the person who brought them here. And so now with domestic, so it's important to kind of think about how to take care of the, whether you can order spousal support under DC law and part of the protection order, for example. There are cases, though, where in a case where a U.S. citizen or lawful permanent resident sponsors their family member to bring them here, they have to file something called an affidavit of support. And that's a great thing for courts and judges to know about, because that affidavit of support is essentially a contract with the Department of Homeland Security in which they sign an affidavit in which they swear that they will be responsible for supporting their family member that they're seeking a visa for, up to 125% of poverty, until that person, it's about 10 years until they would be able to get naturalization, get citizenship. And so that affidavit of support is used in two ways in family court. It could be enforced in a family court proceeding, and there's lots of case law on this, or it can be used as evidence of the ability to pay child support or spousal support, or evidence in jurisdictions where it's difficult to get spousal support generally, they would enforce the affidavit of support as a way to get spousal, by enforcing the contract. So instead of getting spousal support, you're getting the spouse support by enforcing the contract. The other reason that affidavits of support, and there's lots of case law on this, if you have it, we can, Veronica Thronson, who I do a lot of work with, has written whole law review articles on this. But it's very important, but one of the reasons it's super important is that when you file an affidavit of support, guess what the person trying to bring their family members is doing? They are bragging to the U.S. government about how much money they have. And they're providing evidence through tax returns and other things about how much money they have. And some of the judges I train with say, and guess what? What happens when they come before you on the child support or custody case? They are doing what? The opposite, right? They're trying to say they don't have all this money. And so it's a really good way to get some good evidence about what he said to the government he would do, and it also know that that case, that he did file tax returns, and that evidence exists that can be useful in the case. So the other thing that's important to understand is that if one of the things that people aren't aware of, and I think it's important for courts to know and for people litigating these cases to know, is that when if I'm a non-citizen and I'm going to be applying for citizenship, one of the things I have to prove if I have children under the age of 18 is that I've been supporting them. So if in fact there's a court order for child support that I can show I've been paying, that is evidence that helps me gain naturalization. So having court orders in place can actually be beneficial to the non-citizen parent. and have Immigration Act implications for cancellation, removal and naturalization that can be useful to that parent. It also helps for victims, for custodial parents who might have a path to lawful permanent residency, who need to show if they have that they can avoid public charge. So if they've got a child support order that's been ordered for $350 a month, whether or not that's ever paid isn't the issue. They can use that as evidence to show how they're supporting this as part of their income, that that debt is being accrued or whatever in their immigration case to show that they have taken steps to try to support themselves and their children. So it's not about whether it's collected or paid, it's about whether they've gotten the order. So it can be useful because it shows they have good moral character, that they're taking steps to do what they can to be supportive of their child, including getting child support. Failure to pay child support could, in some states, depending on how it's prosecuted, if it's prosecuted, could be a deportable offense. And the other issue is, just so long ago there were cases, and there have been cases since then, where perpetrators have walked into child support cases and say, Your Honor, I'm undocumented, so you can't order me to pay child support. So I may be working, but because I don't have legal permission to work, you can't order me to pay child support. And the courts have basically said, no, that doesn't work. The first case on that was this one that I've given you, assault versus assault, where although, and what this court said in this case, and courts have ruled since then, is if you actually have access to resources, and if you're actually working, or if we can impute minimum wage or whatever it is, we can order you to pay child support even though you're undocumented. Note, judges, you can't order a job search for an undocumented person, because under the Immigration Reform Act of I think it's 86 or 90, it's like helping somebody get a job illegally. So you can impute income, you can expect them to stay in their job and have a job, and if they quit their job, waiting tables so they can avoid paying child support. You can still leave the child support in place if you think you could have a job, but you can't, the job search part you can't do. I actually got a technical assistance question, got the ruling from the IRCA people at DOJ on that one. Wage withholding in these cases is super important. And one of the things that has happened in wage withholding cases is a lot of immigrants work for their brothers, cousins, uncles, or self-employed, et cetera, et cetera. And there have been cases, not surprisingly, where the uncle or cousin doesn't want to do the wage withholding, even they're ordered to do so. And what the courts have done in these cases is made basically ordered that if they fail to wage withhold, the employer is liable for the payment of those child support payments that they fail to withhold after receiving a court order. And there's a whole bunch of case law on that. Proof of income of undocumented parents can be tricky. There's lots of ways to do it. I mean, I did it in one case where we literally took photographs and counted how many hot dogs he sold in front of HHS from his cart in front of him, and brought the evidence into court to try to establish what he was earning. So you have to be creative about the kinds of evidence you will see or accept, but you can also now impute income, and there's a lot of different ways to do it. Okay, public benefits. So just a little bit of true false to kind of get us moving a little bit. True or false, undocumented victims and their children can access transitional housing programs. How many people think it's true? How many think it's false? The answer is it's true. And that essentially there have been transitional housing programs are considered necessary to protect life and safety, and they're by federal law required to be open to everyone without regard to immigration status. If they're a victim of any of the crime victims we were talking about, domestic violence, sexual assault, human trafficking, all of the U visa criminal activities, child abuse, victims of child abuse, abandonment, neglect, runaway abuse, children, and people who are, and the homeless. So if they're homeless, they also are eligible. So immigrants are able to access transitional housing. There are now pretty strong anti-discrimination provisions in the policies and laws that were fairly recent on that. So next one, federally funded health care is available for undocumented immigrants. True? How many people think it's true? How many people think it's false? You guys are good. It's true. But it's true, here's how it's true. The federally qualified health centers, the public health centers and the migrant health centers can provide health care to anybody without regard to immigration status. In DC, additionally, there's district-funded health care for people without regard to immigration status. DHS requires university to ask about immigration status of applicant and enrolling students. How many people think it's true? And I think it's false. It is false. DHS doesn't have any requirements about students and enrollment and application. If people are on student visas, they have certain requirements, but that's different. So what is available to everybody without regard to immigration status? It's programs and services that are necessary to protect life and safety, and it includes legal services. So legal services funded programs are open to undocumented victims without regard to immigration status. Anybody, VAWA, TU, same definition, same list. Children, so if there's a legal services funded program and you have an SIJ child, the legal services program can represent that child if the child can show battery or extreme cruelty. So the abandonment and neglect cases, no, unless the neglect can qualify as extreme cruelty. But they can, legal services funded programs can represent SIJ children and any crime victim in any kind of a case, including representing the mother who's not been abused in a case where the child's seeking SIJ orders. They have access to, all of the different family court proceedings, emergency Medicaid, and parents can get public benefits for their citizen kids even when they're undocumented. The kinds of services that are in kind, so services that are necessary, I should change the picture. I did one the other day, I put Jenna Reno back because this was actually her order. I forgot today. So the services, the Attorney General order, which was issued by Janet Reno, services issued that are in kind, provided at the community level, and not based on the income or resources of an individual that are necessary to protect life and safety are open to everyone without regard to immigration status. And so that includes, that's how you get shelters and transitional housing. And like shelter programs, for example, are not going to turn away the wife of the richest man in town. It's not an income issue. It's about the violence. And the kinds of programs that are necessary to protect life and safety include all of these: crisis counseling and intervention, adult and child protective services, violence prevention and violence and victim assistance, mental illness and substance abuse that's necessary to protect life and safety, so the emergency kind of things that the courts may do. There'll be soup kitchens, adverse weather, community food banks, shelter and transitional housing, I'll explain more in a minute, and then nutritional programs. They can also get education, post and secondary education, WIC, school lunch programs, immunization, emergency Medicare. To find health care, yeah? No.
What'd she say?
Can you get TANF? I'll get to that. I'll explain under what circumstances they can. So I have a whole bunch of information. I'm running out of time, so I've got a whole bunch of information on healthcare. But in DC, they can get the exchanges. I mean, it's quite easy because undocumented immigrants get healthcare. So I'm going to skip that part. Okay, you get transitional housing, and on the transitional housing part, and then I'm going to get to the TANF piece in a second, is that there are no immigration status requirements for transitional housing. They're open to everybody without regard to immigration status, citizenship, nationality, language ability. It can be federally funded programs under all of these programs, and there are anti-discrimination provisions. So now, what happens is when people, and part of the reason I spent all that time on the immigration statuses, each form of immigration relief as you start pursuing the immigration relief, comes with access to certain public benefits. And things like driver's licenses are considered public benefits. So the federal law basically says people who are qualified immigrants are eligible for some federal and state-funded public benefits. Which benefits they get depends on their immigration status, when they entered the United States, which program they're seeking, and that's the TANF issue, and where they live. So DC is different from Virginia, different from Maryland, different from Oklahoma. It's all different. Every state's different. We have a map on our website where you can go and look up, and I'm going to tell you DC. So, so what programs are restricted? What's benefit of a state or federal public benefit are the ones that are restricted. There are payments made, and this is state and federal public benefits are defined as payments made to an individual, a household, or a family eligibility unit. So funds that go to the shelter or the rape crisis center are not considered federal public benefits, even if they pay somebody's rent. So the kinds of things that are restricted that they get with immigration status include TANF, health care, disability, post-secondary educational grants and loans, public and assisted housing. So who gets the most? So the most public benefits, trafficking victims. They get everything. They get everything just like citizens, pretty much. They get everything refugees get, which is pretty much everything. Next most are VAWA self-petitioners. They're considered qualified immigrants about 2 months after they file, and they and their children get access to public benefits, and I'll go over what those are. Battered spouse waiver applicants also do. U visas only basically get health care. It's really, they get much less than everybody else. Special immigrant juvenile status, on application they get health care. After they get lawful permanent residency, they get more benefits at that point. DACA victims, DACA kids, only get driver's licenses and work authorization. They get on nothing else. And health care in DC. They get health care in DC. So who are the qualified immigrants? Qualified immigrants is a broad list. It's much bigger than we've been talking about the victims, VAWA, TSUs, SIJ. They're lawful permanent residents, refugees, asylees, trafficking victims, and the VAWA self-petitioners, which is the last one. For domestic violence cases, when you start talking about public benefits, it includes people who filed for VAWA self-petitions, but also one group of people where their husbands filed for them, and the case has been approved, but they're waiting to get their visa. So there's one group of people that qualify as self-petitioners for benefits and public and assisted housing that are not normally considered self-petitioners under immigration law. So what do they get? So they're all people who are qualified immigrants. All these people on this list here, where to go, get public and assisted housing, post-secondary education grants and loans, access to TANF-funded subsidized child care in addition to child care block grant funded child care. They get low-income residential, like the LAHEAP it's called, it's for heating and things like that. Disability benefits, they can be they get foster parent payments, they can get adoption assistance, supportive housing for the elderly and disabled. Education, we talked about this, but that the immigrant victims who are eligible for grants and loans, federally funded FAFSA, are VAWA self-petitioners and their children, SIJS children who get permanent residency, trafficking victims who apply for T visas or have continued presence, refugees, asylees, and that's it. Child care development funded child care is based on the immigration status of the child, so it's more available than TANF funded child care, and there's no restrictions on a program that has public or educational Head Start standards or is run by a nonprofit organization. So the answer to your question, Judge, is TANF. In DC, Under federal law, you can only get TANF if you've been if you entered the United States before August 22nd, 1996, or if you have been a qualified immigrant for 5 years or more. So there's a 5-year bar to TANF, okay? SSI also is very restricted. Food stamps is the least restricted of these. There's a 5-year bar for the adults, but children of people filing for VAWA self-petitioners, not U visas, VAWA self-petitioners can get food stamps, and health insurance is paid by the state. So that, yeah.
Oh, you have?
Sorry.
What if the parent is not a qualified immigrant, but the child is a citizen and qualifies for Social Security disability? Can you still?
The parent can go in and apply for the child. Now, what's really important to understand is they shouldn't be going and applying themselves. They shouldn't be walking in and trying to apply themselves. They should be going with an advocate and an attorney assisting them. Largely for 2 reasons. One, a benefits granting agency that knows that believes it knows that somebody is here unlawfully is supposed to turn everybody into DHS. There are regulations saying when they know, and those regulations say they only know when there's a deportation order. But that assumes that the benefits worker knows the regulation. So it's safest to go with somebody. And the other thing that happens is that child is eligible, they might get confused and start asking questions about the parent that they're not supposed to ask and end up denying the child because of the parent status, which they're not supposed to do. So having somebody who can document what's going there, who can be, and we do lots of technical assistance on this, so you know, a victim advocate or attorney in DC who wants to go apply, we can walk them through and make sure they have the right papers with them so that they can show the benefits worker essentially their statutes and policies so they get it done right. But yes, citizen children can get everything they're entitled to as citizens. It's just you have this hurdle that the benefits workers may not be educated about who they're supposed to be asking information about. So there's this 5-year bar to these benefits in particular. Their federal means tested public benefits have a 5-year bar. Housing does not, education does not. States, though, have the option to provide state benefits. And what DC has done is there is access to health care for anybody without regard to immigration status in DC, and there's limited driver's licenses to anybody without regard to immigration in DC. And now there's and so the health care comes in 2 ways, and the education I'll get to in a minute. There's DC Healthcare Alliance, and this is open to all adults without regard to immigration status. And then there's healthcare through, there's an immigrant children's program in DC that's for immigrant kids. And that's for kids ineligible for Medicare. And so the only kids that would be eligible for Medicaid is once the SIJS kids get lawful permanent residency, they're Medicaid eligible. Once, but they're Medicaid eligible, no, it's after 5 years. They have a 5-year bar. Because once they become lawful permanent residents, there's a 5-year bar. So DC covers the first 5 years, then Medicaid picks up. Same thing with VAWA self-petitioners and their kids. U visa victims are never Medicare eligible. They're never eligible for Medicare. They're only going to be always DC. Driver's licenses, they have to have resided in DC for 6 months. They have to be ineligible or not have a social security number. They have to prove identity. So again, protection order judges, you know, proof of identity, making sure they have a passport, or there may be a reason to have exchange of documents or get copies of documents so that they can get a driver's license in DC if they fled the home. Those of you working with victims, you want to do safety planning to try to make sure they bring those documents with them. This limited purpose driver's license is not available. It's not good for federal purposes, so you can't get on a plane with it. But it allows you to drive and get insurance and all that kind of stuff. Lastly, DREAM Act, UDC, brand new. April 15th, 2017. So as of that date, all persons without regard to immigration status may pay in-state tuition at UDC and receive local financial aid from UDC if they attended a high school in DC for more than 3 years. Doesn't have to have graduated from DC high school, but if they attended for more than 3 years. Ultimately, they could have graduated from a DC high school, so they could have been here 1 year and graduated from DC high school. That's also sufficient. Or they have received an equivalent of a high school diploma in DC. Whoever offers that program, whether it's whatever that program is. So that's what DC offers in terms of benefits. So I actually got to the end in time.
Does it matter whether it's public or private high school?
No. Any high school physically in DC, it's not public or private. So that gives you hopefully an overview of public benefits, some of the family law issues, what kinds of immigration relief. Thank you all for all of your patience, and I appreciate your time and attention. There's lots of information available, and please make sure you have cards and pens before you leave so you can call us for technical assistance and help. Thank you so much.
I just wanted, again, thank Ms. Arloff. She never broke. She spoke for several hours, and we're very appreciative. It was packed with information. Thank you.
Thank you very much.